Hi, I'm Greg Dell with attorneys Dell and Schaefer, and I'm here with attorney Alex Palamara, and we're going to talk about disability insurance lawsuits against the Sun Life Disability Insurance Company. And Alex, as you know, Sun Life is a Canadian-based company. However, they do a decent amount of short-term and long-term disability insurance benefits in the United States. It's almost exclusively group employer-provided, ERISA-governed long-term disability insurance policy. So the lawsuits that we're going to talk about are those that are governed by ERISA. This is after a claimant has exhausted their appeal, and I know you've handled tons of Sun Life disability claims, and I want to initially get your view on how Sun Life is compared to the other disability companies out there in terms of, first of all, do you see them within the top 10 largest companies, and then their demeanor and attitude towards claims?
Well, they are not one of the top 10, or they might be in the top 10, but they're not the ones that we sue the most, to be honest with you. We don't get a lot of people calling us about Sun Life group disability insurance denials, but we do sue them a fair share amount of times because they do deny a lot of people. Now, I actually get a lot of phone calls. Someone says, I'm dealing with this insurance company, or I'm dealing with that insurance company. I read online that they're the worst. But truth be told, they're all pretty much one and the same, where they're all pretty much denying a lot of the claims that they get their way.
Okay. I find Sun Life to be unique in their approach to claims because of their internal structure. In my opinion, they write one of the most in-depth denial letters of any of the disability insurance companies. When, for example, compare them to a Cigna. How many pages is your common Cigna denial letter?
3, maybe 4.
Right, with half the page being the address, their logo, and then the other half being their block line. Whereas, and what do you usually get on a Sun Life denial?
8 to 9.
Okay, so significant difference, and a lot of it is not necessarily form information. So, where Cigna's like, let's do the bare minimum and deny the claim and then do more later, I feel that Sun Life actually digs in a lot more, obviously in the beginning, and really tries to make it where their appeal is not going to be their go-to catch-all, but they're going to try to front load it up front and do a review on the claim. Has that been your experience?
Of course. They don't do a bad job of denying the claims. They seem to do a better job of denying the claims. They actually make it a little bit more difficult to win the lawsuits against Sun Life as versus other insurance companies that we previously mentioned. And the longer the denial letter, sometimes I say to myself, the harder it is to win a potential lawsuit. So when I see a long denial letter, I kind of sometimes get a little bit fearful, but then once you get into most cases, you can find ways around what they've done.
Yeah, it's not so much the length of the denial, whereas, just to say Cigna, but they'll say, well, the restrictions and limitations aren't supported by your medical complaints. And then it's like, well, what are you relying upon? Whereas Sun Life is better trained, doesn't have as high a volume, and will tend to lay out the medical issues. Now, it could be 15 pages long because our client has had treatment for 2 years and they have extensive medical records, and is all they did
as a summary of the medical records.
Right, was hire their in-house nurse to create a medical summary, and they regurgitated that, and then you're reading it and going, oh, this person's definitely disabled. Then you get to the conclusion, which could be the same conclusion we see in all their denial letters, basically says...
Same paragraphs.
Yeah. Your symptoms don't match the objective findings, or you have a limitation, or we don't feel that it raises to the level of limiting you from working. The typical type stuff. So the detail and the length doesn't necessarily make it any better, but they do look into it. Now, the other thing is their in-house resources. Do you find they go more in-house or out-house? And when I say out-house, can you clarify?
Well, regarding out-house, we're talking about they hire quote-unquote independent physician reviewers to conduct a review of the medical records, or maybe they send someone to independent medical examination. Some insurance companies do a better job of going independent and going outside, so it's not their own employees conducting reviews of the claims. And some insurance companies just rely on their own employees, which I consider them to be very biased people, because if they find for the claimant, they're kind of going against their employer and making their employer potentially spend thousands upon $1,000 per month for years on end.
Right, and that's the person who's paying their paycheck.
Exactly.
So, that's kind of the whole fallacy in the ERISA system is, hey, we denied you. Guess what? You have to appeal. Who do you appeal to? The same company, right. The same people who are employed. They're the payor and the decision maker, and then they get to make that decision, and it's supposed to be fair and impartial, which oftentimes, unfortunately, it's not. When you finally get done with this appeal and then you file this lawsuit, all of these are filed in federal court. Can you explain why it has to be in federal court and why we can pretty much put these cases in just about any country, any court in the country?
Well, they're federal laws. The Employee Retirement Income Security Act are federal laws that govern these group disability insurance policies, or most of the group disability insurance policies, so you're forced to file it in federal court. Now, there's a lot of case law out there that essentially states you can file these lawsuits wherever the insurance company is actively engaged in doing business. And the great majority of all the insurance companies are actively engaged in all 50 states, if not every single jurisdiction throughout the 50 states. I can assure you that they're all practicing down here in the Southern District of Florida, where we file the great majority of our lawsuits. Maybe sometimes it's favorable to file in a different jurisdiction. For the most part, we can file them all down here.
Yeah, and we file all over the country based upon the law that's going to be best for the claimant, whether it's, wherever. We've done California, Hawaii, Philadelphia. Basically every state almost we've filed, and there's some we want to stay away from because it's just not a pro-claimant type circuit. So we'll discuss that with you when you give us a call based upon the different locations that are available. But that's not a that's not a major factor. The fact is you're in federal court, you're getting a review by a judge. Now, in ERISA, most of these policies have a discretionary clause. However, there are some states that don't have discretionary clauses. Can you explain the difference and why, if there is a discretionary clause, that it makes it more challenging for a claimant to win their long-term disability claim?
Discretionary clauses are the worst thing possible in your disability insurance policy. When there's a discretionary clause, it essentially states that the insurance company has discretion to interpret the plan documents and to award or deny benefits, up to their discretion. Essentially whatever they want to do, they can do. Now, if this discretionary clause is in your policy, it does two things. It changes the standard of review that the federal judge utilizes in determining who should win the lawsuit. Now, if there's no discretionary language or discretionary paragraph in your policy, the judge will review the case de novo. Essentially, the judge gets to review all the information and make his or her own decision whether he or she believes the person is disabled. If there is a discretionary policy, the judge then has to first perform a de novo review. If the judge finds that you are disabled, then the judge has to go to kind of a second step and make a determination whether he or she believes that the decision by the insurance company was arbitrary and capricious. This is a much higher standard to satisfy in any case. So de novo versus arbitrary and capricious, you want a de novo standard review. But if your policy, and most of the policy nowadays, contain this discretionary clause, we have to prove that the decision by the insurance company in denying your case was arbitrary and capricious, which is pretty tough to do, but we get the job done.
How strongly does Sun Life believe in their position when you're litigating versus, say, some of the other companies?
Well, I can tell you that I've never had a case against Sun Life where we're litigating with them and they say, you know what, we're wrong, let's put the person back on claim. It's never happened to me. I'm sure it's happened in the past, but to my personal lawsuits, it's never happened yet.
Whereas we have had that happen periodically with other carriers, so they kind of have a very high belief in their people or whatever it is, and just say, we're going to live and die by this decision regardless of what the outcome is, has been my strategy. And what are the common resolutions of a claim, of a lawsuit, that somebody could expect?
Well, the great majority of any lawsuit, whether it's a disability insurance claim, whether it's a car accident claim, a slip and fall, even a criminal lawsuit, when people are charged criminally, it's also a lawsuit. Most lawsuits end in settlements, no matter what law is governing these claims. Just because a settlement gives, there's uncertainty in any lawsuit, and a settlement will give every single side certainty. When you come to a settlement, you know what you're getting at the end of the day. The whole bird in the hand versus two in the bush thing. Letting a judge decide, especially when there's a discretionary clause, can be very tricky because the law is against you, number one, and number two, you don't know which way this federal judge might actually go. They can be a very conservative judge that they basically find for the insurance company all day, every day, no matter what. Or they can be more on the liberal side and maybe look further into the case and maybe see that there's medical documentation that the insurance company ignored or they overlooked, or they or maybe that they find an issue with the reviews that were conducted by the insurance company. But most cases end up in a settlement for that reason, because you don't know which way a judge may or may not go in deciding any case.
I want to talk about what a settlement means and what someone could expect. And people always say, well, what's my case worth? Well, first of all, there's so many factors that go into what it's worth because of the fact, first of all, how much is your monthly benefit amount? what type of definition of disability do you have? What jurisdiction are you in? Are we dealing with de novo, or are we dealing with arbitrary and capricious like you just said? Do we have any limitations in the policy that are going to limit the benefit pay period time? How old are you? How much time's left? So there's lots of factors. Then it gets into what's the quality of review that they did on the appeal. Not just the initial claim, but what did they do on the appeal versus what is the information that you submitted as the claimant. Now, if we handled your appeal, obviously we know and we're in a much better position because we helped to shape that appeal. But if we didn't do your appeal, we have to get the claim file and review everything that not only you did on your appeal or a different lawyer that you may have had, but also what did the disability insurance company, Sun Life, do on the appeal in their review to see if they acted arbitrary and capricious, or just do they have good evidence to support their claim. And that's the art of what we do when we're evaluating the claim. But the reality is that the vast majority, as you said, of these claims end in lump sum settlements. And the valuation that people want to know is that, look, if this was undisputed, and sometimes Sun Life does buyouts, you're looking at 75% of the present value of the future payments. Right. And if it's a disputed claim, you're looking at anywhere from 20% to 50% because of the fact that Sun Life can pay their lawyer 50 grand, 100 grand, defend the case. And if the upside is 500 grand that you could possibly get as payments, and they only have to pay their lawyer 10 or 20% of that, and there's no bad faith, no penalties, maybe there's going to be attorney's fees that they have to pay, then there's no risk to them to spend 50 or 100 grand if they can avoid paying 500 grand. So that's very often why you see settlements in these cases, because then they make an offer where if their case is worth 500 and they offer you 250, it may not make sense to roll the dice if your back's against the wall to try to double your money when you have a level of certainty. So there's cases we tell claimants we absolutely think you should settle, and there's cases where we say under no circumstances should you settle, but you're the boss, the client, right? You make that final decision, as all we can do is give the advice, and the claimant should know that we have the tools and the skill and everything else necessary and the experience to fight for you however we can, and that's what we want you to understand. So if you have a claim that's been denied, feel free to give myself, Alex, any of our attorneys a call. We help clients all over the country. We make it a very easy process where we provide you an initial free consultation. As all we ask you to do is send us a copy of your denial letter, send us a copy of your policy. We'll get on the phone with you immediately. You're not going to speak to a paralegal or a secretary. You're going to get on the phone with a lawyer. We're going to let you know straight away if we think we can help you. Right away, we'll give you a fee proposal as to what we think would be a reasonable fee for your case. We always charge a percentage of the past and the future benefits. The percentages range every time because the benefits range. That's another thing that we're going to let you know right away up front. There's no fees or costs unless we win. So feel free to reach out to us, and Alex and myself, we look forward to the opportunity to speak with you.